India, a testament to our commitment to shaping the future in legal education in India. At Devt, we offer a diverse and comprehensive range of programs that include MBA, MBA International Business, Integrated MBA, BBA General, Integrated BA LLB Honors, Integrated BBA LLB Honors, and LLM. These programs reflect our dedication to cultivating professionals who will lead and inspire in their chosen fields. Our effort has not gone unnoticed. Devt has been consistently recognized for its excellence, receiving the esteemed Grade A from the National Assessment and Accreditation Council in its second cycle. We are an ISO certified institute, a reflection of our adherence to the highest standard of quality. Additionally, Devt has been rated A+ by the State Fee Regulatory Committee of the Government of NCT of Delhi and graded A by the Joint Inspection Committee of both the Government of NCT of Delhi and GGSIB University. Our consistent performance has earned us the highest rating by the Academic Audit Cell of GGSIB University every year since 2011. Furthermore, Devt has been recognized as the #1 top emerging BBA institute in India and ranked #2 for top emerging BBA institutes in placement by the Times B School Survey 2023. But beyond these accolades lies our true mission to create nurturing environment where knowledge meets curiosity and education fuels the dreams of tomorrow's leaders. Today's guest lecture addresses a topic profound relevance: role of international bodies in development of human rights law protecting vulnerable population. Case studies from international jurisprudence. On behalf of Gita International Business School, we are honored to welcome Dr. Vinai Singh as our esteemed and distinguished guest speaker. Now I would like to invite Dr. Nidhi ma'am to present a memento to our guest of honor for the day. A round of applause for her. Thank you, ma'am. Thank you, sir. Dr. Singh is a senior assistant professor and a deputy director at the Indian Society of International Law, where he has been serving since 2004. With over 19 years of experience in teaching and research in international law, Dr. Singh has made significant contributions to the academic field of international criminal law, international human rights and humanitarian law, international economic law, and dispute settlement. He holds a PhD and MPhil from Jawaharlal Nehru University, New Delhi, and an LLM from Delhi University. In addition to his teaching and roles, Dr. Singh has served as an assistant editor of the Indian Journal of International Law from 2009 to 2023, and his expertise has been widely recognized through numerous peer-reviewed publications. Some of his notable works include articles in prestigious journals and edited volumes such as Indian Journal of International Law, Italian Yearbook of International Law, Brazilian Journal of International Law, and ISIL Yearbook of International Humanitarian and Refugee Law. His research on topics like Indian treaty making power, dispute, settlement mechanisms under UN laws, and the role of international law in refugee protection has earned him recognition. Dr. Singh has made significant contribution towards research in international law, having written extensively on the operationalization of state and non-state actor duties in international law, the inclusion of war refugees in African states, and the challenges posed by Indian legal system in relation to international treaties. It is truly a privilege to have Dr. Vinai Singh with us today to share his insights on the role of international bodies in development of human rights law, protecting vulnerable population, case studies from international jurisprudence. We are eager to hear from you, sir. Without a further ado, please join me in extending a warm welcome to Mr. Vinai Singh. Welcome, sir.
Good morning to everyone. I make apology for being late around half an hour, and I was just struggling to find location. Let me do at the outset thanks to Gitarathan International Business School inviting me to share my thoughts on the very important topic of human rights law. And I especially thanks to Dr. Vikas Kumar, Director, and Dr. Kalpana Devi and Singh, who has basically made me to understand what I am supposed to speak to you. And little bit modification in my introduction. Now I am no more with the Indian Society of International Law. Presently I am working with the Jawaharlal Nehru University as Associate Professor in Center for International Legal Studies, School of International Studies, Delhi. And the center particularly teach only the international law component. And my area of specialization is fortunately loving with the international trade law as well as human rights law. More specific. I'm quite sure August gathering is well aware about the various, and it seems that if I'm going to share some thought on it, I hope that I would get some sense from gathering as a student how we should feel this subject has to act. I'm audible to everyone? Yeah, thank you. So, let me to begin. I'm quite sure you must have been looking up the newspapers and looking about the India's basically performance or India appraisal about the human rights report. And I'm quite sure you must have been also come across that there were certain news appear recently in 2024, May or May, June time, that NHRC, National Human Rights Commission of India, could not able to get what you can say accreditation from a global alliance group which has been known to recognize the national institutions, and it is very setback for India in terms of that. It is the place where any country would like to see to be there, and India has played active role through this being accreditation of A category with the Global Alliance of National Human Rights Institutions. And this news appeared at a time when also the at the same time when India's civil and political right was submitted to the Geneva Human Rights Office. And in this context, this is two important performance. And let me do little bit give you basic introduction about the subject. You all know the UN Charter is adopted in 1945. At the same time, with that one, you will find a Universal Declaration of Human Rights adopted by the UN General Assembly in 1948, which give a shape to discipline of human rights and the international legal regimes, and which gradually has expanded, and it been what you could see that expansion is with the civil and political right, it will coordinate on civil and political right, then it will coordinate on economic, social, cultural right, and subsequently there were 8 more international instruments pertaining to human rights has been adopted. This gives an understanding a series of the international treaty conventions has been adopted to what you can say underline the importance of the human rights law, but particularly the initial phase could be seen is to encourage to respect the human rights. And this language has been used into the UN Charter as well as with the UDHR. More or less, this terms is going to expand. Encourage to respect is going to expand, and today's discussion is that how this respect has to be also somehow to be imposed in terms of that the states and otherwise also individual human beings could also secure their rights through these instruments. In last 1.5, next 1.5 hour, we will try to see how this is being evolved over the years. And keeping this one, let me to take to you as I said that UDHR has been adopted in 1948, but before that there was an institute which is known as the Human Rights Commission, which has basically begins with the work to codify the human rights law. And this institution is being seen in the context that how it has been evolved. Because from this one, you will get a sense that what is going to come from the international regimes to see implementation of the human rights. And it will give you insights to understand that there was complexities under which it was evolved. So considering this point, this what you can say the complexity, it is important to understand the role of the Commission on Human Rights. As I said, this is the UN Commission on Human Rights, and it is being known as a charter-based mechanism. Besides that, there is treaty-based mechanism. So charter-based mechanisms evolved through this UN Commission on Human Rights, whereas the treaty-based system has been what you can say grown through the various separate treaties. So there are two separate parallel what you can say regime has been there. One regime which has been around the charter-based mechanism, another one is the particularly the treaty-based mechanism. I'm quite sure you understand. Once someone says that charter-based system, it means that it evolved through the charter, United Nations Charter, and the treaty-based system which through the diplomatic negotiations, through the what you can say plenipotentiary, a treaty has been evolved, and through the treaty the rights are being guaranteed. As I said that the civil and political rights instrument treaty, then economic, social, cultural rights treaty. Then you may be aware about the Convention on Elimination of Racial Discrimination, which is known as the CERT. Then you have Convention on Discrimination Against Women, that is basically CEDAW. Then you will find CRC, Convention on the Rights of Child. Then several other conventions are there. Around 9 core treaties is available. At this moment, we will not try to go to each treaty to understand the issue, but more or less to see how these have been evolved over the period. So, like as I said, this commission evolved in 1946 before the adoption of the UDHR. So you can understand the sense how it could be a crucial period for the human rights regimes at international level. And there is a sub-commission which has also been evolved. There is a Human Rights Committee which is known as a treaty-based committee. In terms of that treaty, the civil and political rights has got to submit the report and assistance to all human rights treaty. Then we have regional human rights institutions like African Court of Human Rights, African Commission on Human Rights, European Commission on Human Rights, several other regional regimes is there. Now, as I said that, in this context, the important point for all of us to understand whether we need a human rights regime, international human rights regime, which could be seen to globally regulate globally make the implementation of globally so that respect to human rights has to be guaranteed. So one is that which has been known as that whether you need a global level regimes to be established, or you need somehow to still maintain that the nation itself is competent to give the respect to the human rights. Considering these two competing objectives, one hand to globally to see implementation, another hand to see that through the national mechanisms it could be respected. This competing objective has led also to somehow to difficulties to tackle by this evolution of the institutions pertaining to the Commission on Human Rights. So those who believe that country is being sovereign, nations are sovereign, have been given the freedom to exercise their what you can say prerogative under international regimes has to be maintained. So a traditional image has been there at that point of time that international regimes may interfere into the domestic affairs of the country, and which led maybe considering that there are many states which found that had the apprehension, like Russia and what you can say East Bloc had the apprehension that by this mechanism, by virtue of this human rights regime, the West, particularly West European states, would intervene in the domestic affairs of the Russia and Eastern European countries. Dilemma at that point of time, it would be seen that there was resistance to the globally emerging human rights regime at that point of time in 1946. And on the other hand, there were scholars, there were supporters to champions to the human rights causes who advanced the view to support the globally recognized rules to establish that international. So this two competing objective has basically influenced the process of adoption or institutionalization of the Commission on Human Rights. In this terminology, you find that there could be a middle path can be possible to be adopted. Middle path can be like let the norms to be settled by the global institution and leave the implementation part for the domestic countries or nations to implement it. So the globally what you can say a norms can be established for human rights and leave the implementation part to the nations, to the state to ensure that human rights has to be enforced. So considering this point, the initial evolution through this UN Commission on Human Rights remaining to be seen in the context is more like a norm setting institution. So this Commission on Human Rights begins with the work with what you can say drafting of UDHR and International Covenant on Civil and Political Rights, International Covenant on Economic, Social Welfare, and many other treaties which you could see it emerged out because of the efforts of the Human Rights Commission. Now, as I said that the contention about that how this institution, what mandate has to be given this institution. So as I mentioned that one is that globally accepting the norm setting, another is giving enforcement mechanism. Initially, if you look at this commission struggled to see what could be the mandate. In the terms, there is a huge debate has been took place. So the first mandate you could see that formulation of the International Bill of Rights. By virtue of this mandate, the Commission was successfully able to adopt three instruments which is known as International Bill of Rights together, which is UDHR, ICCPR and ICES. All three together constitute to set to an International Bill of Human Rights. Then thereafter subsequently they have been given to see the second mandate formulation of the pertaining to declaration of convention pertaining to civil liberties, status of women, freedom of information. You could see that this mandate is important in that context. Then protection of minorities. Then further you see that prevention of discrimination on grounds of race, religion, language. In this whole context, the last one is very crucial for give a sense to understanding the what you can say the futuristic or in the terms of the holistic visions to institute this Commission on Human Rights. Considering this point, the fifth mandate remains to be very contentious. The fifth mandate has been like a different is that debate about what could be the mandate of this commission. The competing what you can say claim could be seen in that one option was given that whether open-ended mandate should be given to the Commission on Human Rights. Open-ended mandate means that any subject matter of the human rights should be given to the Commission to develop it or to make sure that in future it could be tackled. Another one is being said that if you read that another option, any matter within the field of human rights considered likely to impair the general welfare or friendly relations with the nation. So there are two competing objectives to receive. One is open-ended mandate, another is known as a closed-ended mandate. So considering that, two options have been given. Another what we can say option was that whether who could represent in this body, whether the government representative only remain to represent this body, or it could be also given to the independent expertise who has the vision pertaining to human rights, could also be allowed to represent in this body. Considering these two, what you can say, the competing objective, competing demands, the need to keep the balance somehow to it, this process of evolution of the Commission on Human Rights. Now, what happened? You know very well, after the negotiation government presented, and they found that it could be more potential to save their own interest. So they were agreed that this institute, this commission should remain only represented by government officers. Other hand, in the what you can say bargaining, the mandate to the commission has been given open-ended mandate. So it is a good in terms of that. One progress to be seen that the commission has got a very wide mandate, open-ended mandate. But other hand, this commission has been somehow be restrained to only represented by the government officers in this body. So over the years, you will see that commission has also evolved certain mechanism that which other than the government officers could be also like non-state actors could be given observer status, or some other institution could be like the National Human Rights Institution has to be given certain role to present the shadow reports or some other aspect. But the initial phases could see that contact in the context which it is an open-ended mandate only limited to presented by the government. To keep that as again that to keep the what you can say the demand that nations are sovereign, states are sovereign, and they would like to retain the what you can say the sovereignty in terms of regulating the any affair, domestic affairs of the country. So human rights issue could be seen as initially could be a issue being seen as it is a nationally issue would be need to be addressed. But at certain point of time or at certain point you would find that nations fail to address the issue of violations of human rights, where you would find that only international mechanisms matters has been taken to resolve. So, considering this point that there is huge what you can say contention can be seen in this context, and you could see that also it reflects in the UN Charter. There is a provision under Article 2 subclass 7 of the UN Charter where says that United Nations cannot intervene in essentially domestic matters of the states. So this understanding is also has somehow given influence the whole process of adoption of the Commission on Human Rights. And considering that one, a middle position which seems to be globally recognized rules has to be established and leave it for the domestic or states to give implementation to it. Now, other mandate of the commission which was been given at that time, that Security Council can also somehow to play a role to aid in the terms of the Commission on Human Rights. Then membership of the Commission on Human Rights. But who could represent in the Commission on Human Rights? How many members has to be there? As you know that this is a subsidiary organ of the ECOSOC, Economic and Social Council, which is still being represented only by 53 states. Considering that a limited membership, it could be seen the Commission on Human Rights could be also with the limited membership. And when it established, it was with 53 members. Considering equating with the Commission ECOSOC to retain the similar status like membership has to be maintained into the Commission on Human Rights. Now, as I mentioned that it is a subsidiary organ of the ECOSOC, and you could understand that ECOSOC is the one organ of the United Nations which look after about economic, social, and cultural rights has to be somehow to regulate by the United Nations. considering this one, that's why this institution is known as a charter-based mechanism, because it is evolved from the UN Charter. Whether the treaty-based systems parallelly has been there, which has been considered as separate regimes, which will be later on subsequently. Now, as I said that initial mandate has been for the Commission of Human Rights was the drafting of UDHR, coordinate, and then CRC and other instruments has gradually been drafted. Latest one was considering that 1986 Declaration Right to Development, where work is undergoing in the Human Rights Council. The initial phase of 1946 to 66 for the commission, they've been considered a application of responsibility. Several scholars have what you can say examined the works done by this commission during till date, and that's why it has been divided in several periods to give you insight how this commission has evolved over the year. 1946 to 66 is known as the application of responsibility, because that commission used to make a statement that their role is being limited. Their role is being given only for norm-setting institution. They cannot, they have not been given mandate to enforce the human rights. And considering that one, 1946 to 1966 is being found, the commission played only role pertaining to norm-setting, like UDHR, International Coordinate on Civil and Political Rights, Coordinate on Economic, Social and Cultural Rights, CERS, all this document has been adopted over the year period. In 1967, ECOSOC adopted a complaint mechanism, which is being considered is a gradually assumption of responsibility by the Commission on Human Rights. And this period considered that where a teeth has been given, a power has been given to the Commission on Human Rights to entertain individual complaint from the individuals. And considering this one, this is a very innovative idea, and which gave how that enforcement of the human rights can be brought in. Over the years 1979 to 2005, there were several discussions took place in United Nations Forum how to strengthen the human rights enforcement at international level. And you know very well that during this period of time, there was Kofi Annan report, which is known as Enlargement Freedom. Then several other reports have appeared, which suggested revival, reinvention of the Commission on Human Rights, which could see that more and more responsibility can take. Considering that in 2006 or 2007, you will find that a renovation has been done with the Commission on Human Rights, which has been renamed as a Human Rights Council. The Commission on Human Rights is renamed as a Human Rights Council, which is currently existing, is now given additional mandate, and gradually you will see that there are several innovations has been done in it, like submission of the UPR, Universal Periodic Report, complaint mechanisms, all has been brought under this regime. Next 10 minutes I will again show you that what I have said, that 46 to 66 period, where Commission often make that they have a very limited role to play with, particularly with the human rights implementation. Then 67-78, you will see the robust regimes pertaining to legal applicants has been developed. The two important complaint mechanisms which I said that has emerged, 35. These two procedures, which is big ECOSOC resolutions, and it provides an individual to file a complaint to the Commission on Human Rights directly over there. But there are certain conditions which need to be fulfilled. That one condition often is being there, exhaustion of local remedies. Anyone who would like to approach to the international forums has to first to explore the domestic remedies. If they are unable to get remedy from the domestic institutions or domestic mechanisms, thereafter only can they approach to the international body to make complaint under the 1503 or 1235. 1503 is known 1503 is known as confidential measure, whereas 1235 is known as a public mechanism, public complaint mechanism. So 1503, as I said, that this procedure is being a confidential measure in which a complaint once is being made against any states for a violation of the human rights by any individual, then the complaint will not be made public. Complaint will not be made public to everyone. Complaint will be only forwarded to the state to seek their opinion how they are going to address this issue. And by what you can say, having a conversation with the government, or having a negotiation with the government, or having a dialogue with the government, they will genuine dialogue. They will try to address the issue of complaint which is brought by individuals. So it is known as a confidential mechanism. It has not been brought to the public. Why it has been made? To ensure that reputation of the country should not get into the picture. And often the state being very particular with maintaining their image international level. Considering that point, 1503 was often being used at that initial period under the Commission on Human Rights. Thereafter, in 1235, you could see the public measures in terms of that this once complaint has been received under this procedures, the complaint will be public, and it could be available to the media, newspapers, to write about what is happening with pertaining to in certain regions or country pertaining to violations of the human rights. And this is being considered more little bit, what you can say, somehow if the grave offences, grave violations of the human rights has been done, this regime could be invoked. And the important aspect with 1235 procedure is that you could distinguish it that if the human rights, what you can say, performance of any state pertaining to human rights has been globally been seen that it has been undermining the human rights obligation, 1235 procedures remain very crucial in that context. What does it mean? That no country would like to see that under 1235 procedures could be, their image could be somehow challenged. So to see that this is a little bit, what you can say, more in terms of the image of the country, it will be very damaging for them, and it is found that more useful in terms. I will give an example to understand how you could distinguish between 1503 and 1235. Like, take an example of Iraq. Before invasion of the Kuwait by Iraq, the ongoing crisis pertaining to human rights in Iraq remains to be under 1503, which is not been found very substantially gross violation. But after invasion of the Kuwait, Iraq would have been found to be put into the 1235 procedure mechanism. To see that it is already been known to internationally, they are the one violator of the human rights violation. Besides that, over the years there were other mandates have been included into the Commission on Human Rights, like appointment of special rapporteurs, also special representative from the United UN Secretary General, which always visit to the states wherever there are grave violations of the situation of human rights as well as now. So these are the several ways mechanisms have been over the years included into a mandate of the, what you can say, new invented human rights council. Then also found there is another way to look about implementation is country mandates. You may have heard through newspapers several special rapporteurs, representative has been appointed to look after about certain countries' performance pertaining to some of the situation. And that's why over the years this mandate has been just for general understanding, there are huge regimes evolved now for pertaining to implementation of the human rights. As you see that a complete mechanism has emerged in 1976, And thereafter you could see also appointment of special rapporteurs, which added to the more teeth to that role of the commission. And then country mandate, all this has been simultaneously operated. And often a country which has been under scanner of this violations of the human right, often being subject to most of the, what you can say, the mechanisms which is available before them. So, just to give to the sense that initially the commissions was being, the way it started, it was very non-setting institution, but over the years it has evolved, shaped into the implementation of the human rights. As I mentioned you that the Human Rights Council, which is reinvented in the Commission on Human Rights, and it is basically after the suggestion of the Kofi Annan reports and other high-level panel reports which came out, where it suggested that commission has to be strengthened. And a similar debate what you see was appearing in 1946, again appeared in 2006, when the re-envisioning the whole Commission on Human Rights was there. And you could see that there are what would be the mandate, who can be present within the body, what role has to be given this Human Rights Council, all has appeared. The beauty is that after several rounds of discussion or negotiation, finally the state agreed to arrive to certain consensus. And next 5 minutes I will tell you what an innovation has been done. One is that the commission status has been elevated. The council, Human Rights Council, which is being reinvented, is now become the subsidiary organ of UN General Assembly. Earlier commission used to be subsidiary organ of the UNOSOM. So elevation of the status of the Human Rights Council within the UN Forum has given a more what you can say prominence in dealing the situation of the human rights. And you know very well the UN General Assembly is one of the body which also has the power to pass the budget about the activities of the United Nations. Considering that point, the human rights, what you can say, the aspect could be seen, could get more support in the terms of that basically from the United Nations in budgeting to deal the issues pertaining to human rights. Another aspect which you will see in this one, how many members could be there? Few states like European states were willing that or were basically they were supposed to give the more limited membership to the commission. It means that they want that the earlier what you see that 53 members used to be there. Their condition was that the European demand was that it should be made more limited membership. This was being basically what you can say. This idea was being given to the sense that the only states who perform good into the terms of the human rights will only eligible for the membership of the council. Considering that point, they want that by regulating the membership, they will give a sense to the state unless until you won't perform to deal with the issue of human rights at your national level, you would not be eligible to become the member for it. So considering this point, they recommended that the Human Rights Council should be somehow to be limited membership. And you can understand that they would like to see as much as restriction has to be, more limited membership has to be given. On the other hand, the Asian African states were very hesitant to this proposal. They were of the belief that by considering the limited membership within the forum, Asian African states will be sidelined from the what you can say the mainstreaming the human rights at the international level. And they were, you know very well, international law is being argued that the Eurocentric nature, and similar contention could be seen in Asian African states while dealing with the subject of the membership pertaining to Human Rights Council. They were of the belief that since the Asian African states were being need some certain supports, need certain spaces, pertaining to the representing within the body. Their demand was that enlarging the membership of the council. So you could see that opposite contention is coming, one from the western state, particularly limiting membership. They were of the belief that by limiting the membership, the performance of human rights can be improved. Whereas on the other hand, Asian African states were very much concerned about that they should not be get sidelined into the, what you can say, within the institutional arena or regulating the affairs of human rights within the institution. They should have their own bias pertaining to taking care about the human rights issue at international level. So, Asian African states have been basically witnessed earlier also by limiting the membership. They were being basically ignored in the terms of that their capability, their capacity building measure. Considering all these points, Asian African states were arguing what you can say a larger body to be established within the human rights council. Another issue was that election and suspension of the members. European state West was one of the belief that for the election there should be more rigid, more what you can say the more rigid system or more rigorous process has to be involved. And they proposed that any state only get elected once they will get 2/3 majority in the election. And for suspension, they were of the view that by simple majority, if any state is found not being performing good on human rights, could be suspended. So for election, a detailed what you can say procedure has to be like a process has to be like 2/3 majority, which is a rigorous process has to be involved. And for the suspension is a simple majority, a simple solution has been provided, which again Asian African state did not agree to this idea. They were of the view on the similar context that Asian African state for long time has been victim to the process of the international institutions. And considering that point, they were of the view that for the smaller countries, it is very difficult to secure the 2/3 majority to get elected within the court. It would be easier for them, for smaller countries, it would be easier to argue for simple majority to get elected within the court. So they argued for the election to be elected member has to be only required to support or to get support with the simple majority. Other hand, for the suspension, since they were of the belief that West always been lobbied among them and sidelined the Asian African state and could be make the receiving end to the Asian African state or make the victim to the whole process of international interaction. So they were of the belief that for the suspension a 2/3 majority is required to secure it. So you could see that a different view paradigms from the West and Asian African state in this process of what you can say reinventing the human rights concept. Finally a compromise reached under which a membership with 47, neither bigger one nor smaller one. It has not been reduced much from 53. It is now been 47. Neither it has been expanded to ensure that European could also be on the similar table. They will be also along with this and possible make possible that new institution could emerge out. And on the other hand, for election and suspension, European West were considered the idea of the proposal from the Asian African state and agreed that election could be done by simple majority and suspension could be made by the 2/3 majority. Besides that, a new mechanism has been brought, which is known as a Universal Periodic Report, which is after 2006. It is very similar to what you can say a periodic report is presented into the committee body. Here a Universal periodic report which has been required to submit by each state after 4 years, which is more or less given a peek to another, more given a power to the to the council better than what you can see that from the Commission on Human Rights. And with regard to special procedure, which is still being continuing, what you could see earlier available in the Commission on Human Rights. At present, complaint mechanism only remains with 1503, 1235 has been abolished, no more has been there. So governing with that 1503 remains to only within the fold of the within this institutional prerogative over it. This gives a clue to how these regimes are being there. Or if you look at it's a series of the you could see that maybe a little bit smaller in terms that it may not be visible to you. But if you could see you visit to the website, you will find that their works are being shown in terms of this table, which give you insights how it deals about it. So this is what I said, that country mechanisms. You could see series of the countries have been brought into this picture. Besides that, there is a treaty-based system, which I earlier mentioned, that the human rights community. So there is a treaty, several treaties are being there, through which the states are being asked to implement the human rights. And these treaties have established committee. And in this committee, once the states are party to the treaty, they are required to submit the report, which is known as a periodic report. A human rights committee which oversees the functioning of the institutional coherent on civil and political rights, civil cultural rights, which oversees the implementation of the instrument of institutional coherent on economic, social, cultural rights. Similar, every treaty has a treaty body, which is known as a treaty committee, and these committees have a recommendatory role, and they have adopted several comments, general comments, pertaining to their, what you can say, role which has been given to look after it. Like Human Rights Committee is look about the institutional coherent on civil and political rights, which has adopted general comment on various subject to it. Now, coming back to the India context, India is a party to the ICCPR and ICCR, but India has made certain reservation into it. UDHR is a General Assembly resolution, which is not a treaty, and the legal technicalities to it. But UDHR is being considered the Magna Carta instrument of the human rights, which is being known as what you can say, a customary rules in the field of the human rights law. So UDHR has gained a status which is known as a customary rules of the, despite it is not a treaty, it becomes binding upon the state. Whereas a treaty, like I said, that international coherent on civil and political rights, economic, social, cultural rights, CEDA, FLIRT, there are several instruments. India is a party to many of them. And India is required to submit periodic reports. As I mentioned that, India recently submitted a periodic report in 2024 with the latest civil and political rights. There were several debates which have appeared. And in those reports, committee made certain recommendations which the state is required to somehow to address those issues. So by virtue of this, what you can say, dialogue approach, a implementation has been of the human rights agency at international level. Now, just to bring you a little bit a context to the subject, the civil and political rights, international political and civil and political rights recognize two types set of the rights. One is known as a derogable right, another is known as non-derogable right. And you do have in your constitution, there are certain rights which cannot be abrogated in any circumstance. Like fundamental right, which is being found that it will remain in all situations, except in emergency situations, you can suspend the few of the fundamental rights. And you know very well, if it is in imposed emergency has been imposed, particularly the 352 proclamation of the President, only Article 20 and 21 remains to force, other can be suspended. There is a derogable and non-derogable right, also similar like what you see in Indian constitutional system, exists to the civil and political rights. And these often debate whether how can security prevent one right over another right. So this debate is continuing over the period, and some scholars say categorizing certain rights over and above the other right is defeating the whole objective of the achieving the human right globally. In terms of that, each right is important, and in this context, the right to development, the declaration remains very crucial. In the context that the declaration unifies the civil and political rights of the economic, social, and cultural. What does it mean? That in early periods, what you see like the fundamental rights and the references of state policy in Indian constitution, fundamental rights has been preference over and above the references of since the constitution has been adopted in that terms. The civil and political rights and economic contest between the civil and political rights, economic and social rights remain in the international trade. That civil and political right has been said by the West to state is more important than the economic, social, cultural right, whereas over the period it has been understood that each one of the human rights is important, and compromising with any of the human rights would be compromising with the human rights within as such. So I will end here with that one, that the declaration is in this case to come as then the drafting is being taking place related to treaty on the right to development. The huge debate will be occurring. If anyone is interested, kindly follow those. It will be very useful to see how the present time the human rights regimes are expanding. One hand, we also see the human rights has been a big challenge in times of that what is a powerful state. But on the other hand, you see also picture that there are several ways the mechanisms over the periods are being brought into it so that the human rights regimes could be further strengthened. So I will end here with this note. Thank you for having present with me. Thank you. Yeah, please. Optional protocol. Second optional protocol of ICCPR. Thank you. Any other questions? Yeah, please.
Can you comment how ICCPR and ICSR complement each other in promoting the human rights?
Good.
Has India filed any individual complaint in human rights committee regarding violation of human rights?
It is a right has been given to individuals, not country. So individual has to file a complaint. Yeah. Any other questions? We can take one or two more questions. Okay. So why India is not party to the second optional protocol? You know that India has been defending their position at international forums for a long time on the ground that the death penalty in India is the rarest of it. And India is also of the view that the crimes, particularly in developing countries like Asian African countries, is being somehow need this type of the punishment. And as it is being said that it is the rarest of rare situation only that penalty is given. So India position is being on this issue like that one. But other hand, there are what you can say NGOs who are even what you can say academia which has support that basically that India should ratify the optional protocol. Considering that India is need to see international globally to be a very respectable country in terms of human rights, to maintain the discipline of the human rights internationally, India profile, they believe that India should become the party. But as of so far, that government of India position is like that. The death penalty in India is the rarest of rare, and several cases have been brought into this context. Now, the second question is related to complementing civil and political rights to an economic, social, and cultural rights, which I ended with one that right to development, definition of right to development was being adopted to ensure the unity, indivisibility of the human rights, of all human rights, and this was in the sense that I said that defeat of one of the rights of any civil political rights or the economic, social, cultural rights, defeat for the all to achieve all of the human rights. And this has been understood recent in all the periods of time. For the West, initially the importance was more related to civil and political rights, and in that context, civil and political rights has given primacy over and above the economic, social, cultural rights. So even at the time of the adoption of both instruments, both instruments have been brought separate, despite that UDHR consists both rights together. UDHR, when it was drafted in 1926, at that time civil and political rights, economic, social, cultural rights put together. They were not two separate instruments was been there. But over the period of time, due to West considering giving the more primacy to civil and political rights, the rights have been adopted, these two rights have been adopted in two separate institutions, which make it understandable to all of us that economic, social, cultural right is not much important as the civil and political right. And this thing has been continued for a long time and give the negligence to economic, social, cultural, which has been very much essential for the newly independent countries or poorer countries or developing countries to achieve. So this is the one crucial objective was that to bring unify the both rights, and this complements the club standard, as I said, that defeat of one of the rights, the defeat of the whole human rights, any one of the human rights and the whole of the human rights. One last question I already responded that India state is not being given right to bring a complaint into the mechanism. Complaint mechanism for individual is being there. So individual complaint mechanisms, like any citizen of this country, if they found that their issue is not being possible to be addressed by the national forums, national institutions, they can make a complaint to the international forum. Provided India is a party to the complaint mechanism under treaty, but with related to the 1503 complaint mechanism under the Human Rights Council, individual has a right to make a complaint over it. So thank you for this all.
Ma'am, to deliver the vote of thanks.
So, as we come close to this session, so as this session is closed now, so now we are going to give the vote of thanks to our renowned professor, Dr. Vinai K. So, as you know, the topic of this session was role of international bodies in development of human rights law, protecting vulnerable population. So, on behalf of JIPS, CLS, Center of Legal Studies, I am extending heartfelt thank you for the professor. Your insightful session, it was an insightful session, and wonderful knowledge you have shared with the audience and to the students. I am sure that these will enrich them and this will help them for their future endeavors. I also want to extend the heartfelt thank you to DC sir and the director sir for all the support they have given to us for organizing this conference. This particular event. I also want to extend my heartfelt thanks to the audience